Sometimes the biggest fights start over the smallest things. So what happens when a simple neighborhood disagreement about meeting notes spirals all the way up into a formal legal hearing? Well, today we're heading to Tucson, Arizona to find out. This is a story about altered records, some mysteriously missing recordings, and a really crucial legal question. Who has to prove what? And there it is, right from the official petition. This is the core accusation. A homeowner named Jo Ann Ripley is claiming her homeowners association was, well, literally rewriting history. And that single charge, that's the spark that's about to ignite a huge legal battle. Now, this isn't just any homeowner getting into a tiff with the board. Nope. The person making the accusation is a former HOA president herself, which means she's challenging the very people she used to lead. So let's take a look at who's on each side of this fight. Okay, so on one side, you've got Jo Ann Ripley, the petitioner. And get this, she'd been on the board herself, right up until early 2014. On the other side is the Agua Dulce Homeowners Association, represented by its president at the time, Linda Ware. This is basically insider versus insider. It's going to get complicated. Miss Ripley's claims were incredibly specific. We're not talking about a typo here or there. She alleged that for 3 separate meetings, her objections were just deleted, that things that never even happened were inserted into the record, and maybe most seriously, that actual vote counts were manipulated before being posted online for everyone to see. She was basically accusing the board of creating a complete work of fiction. But, of course, there are always 2 sides to every story, right? The HOA had a rebuttal, and their entire defense really came down to a totally different idea of what an official record is even supposed to be. And this, right here, this is the heart of the whole disagreement. See, Ms. Ripley thought of the minutes as something close to a transcript, a detailed play-by-play of who said what. But the HOA, they argued that minutes are just a bare-bones summary. They're not meant to capture every comment. They're just there to record the official actions and nothing more. And this is a really important point in their defense. The HOA said these weren't some secret, sneaky changes. Their president testified that the entire board reviewed the minutes, voted to approve them, and officially ratified them before they ever went public. So from their point of view, this wasn't an alteration. It was just their normal official process. So by now, you're probably thinking what I'm thinking. There's an easy way to solve all of this, right? In a classic he said, she said dispute, you just go to the tapes. Well, this is where the story takes a really fascinating and, let's be honest, frustrating turn. I mean, this is the question everyone, especially the judge, must have been asking. If the meetings were recorded, this should be an open and shut case. But that definitive silver bullet proof was about to vanish into thin air. Oh man, this is where the case just completely falls apart. First up, the HOA's official recordings, poof, they're gone. A former manager apparently taped right over them. But wait, Miss Ripley says, I have my own personal recordings. It feels like a breakthrough moment, except when she plays them for the judge, you can't hear a thing. It's totally inaudible. And to make matters worse, she couldn't provide copies for the other side. Just like that, the definitive proof from both sides had completely evaporated. So with no clear evidence, no audible recordings, and 2 completely opposite stories, how on earth does a judge make a decision? Well, it all comes down to a fundamental legal principle that decides cases just like this every single day. And that key concept is called the burden of proof. It's a simple but powerful idea. The person making the accusation has the responsibility, the burden, to prove it. It wasn't the HOA's job to prove they were innocent. It was Ms. Ripley's job to prove they were guilty. And the specific standard she had to meet was something called preponderance of the evidence. So what does that fancy legal term actually mean? It's pretty simple. Think of the scales of justice. To win, Ms. Ripley didn't need to prove her case beyond a reasonable doubt like you see in criminal trials on TV. She just had to provide enough evidence to make the judge believe her story was more likely true than not. All she had to do was tip those scales, even just a tiny bit, in her favor. And here we have it, the judge's final word. Because her evidence, the inaudible recordings and her personal notes, couldn't tip those scales, she officially failed to meet her burden of proof. The judge just wasn't convinced that her story was more likely true than the HOA story. So, the outcome was decisive. With the burden of proof not met, Ms. Ripley's petition was dismissed. The Agua Dulce HOA had, legally, won the day.
Okay, so why are we talking about a small HOA dispute from years ago? Because it's a perfect little case study in how organizations work and just how fragile proof can be. There are some huge lessons here for anyone who's ever been part of a club, a board, or any community group, really.
So, what can we all take away from this? First, define your terms. Before a fight ever starts, everyone needs to agree on what meeting minutes are even supposed to be. Second, keep good records. The HOA got lucky that the petitioner's evidence failed because erasing their own tapes was a huge, huge mistake. And finally, and this is the big one, an accusation, no matter how passionate or serious it is not the same thing as evidence. Without proof, it's just a story. And in court, the person with the burden of proof will almost always lose. And that brings us to our last thought for today. The next time a disagreement pops up, at your job, in your neighborhood, maybe even in your family, think about this case. It's not always about who's right or wrong, but about who can prove their side of the story. So ask yourself, in your world, when push comes to shove, who holds the burden of proof?